Public Law 11053, Section 1534, Over-the-Road Busing Security Training Program. A, in general, no later than 6 months after the date of 6 United States Code 1184 deadline regulations enactment of this act, the Secretary shall develop and issue a regulation for over-the-road busing training program to prepare over-the-road busing frontier employees for potential security threats and conditions. The regulation shall take into consideration any current security training requirement or best practices. One consultant with the Secretary should develop regulations under subsection A and in the constant within one, appropriate law enforcement, fire services, emergency response, security, terrorism experts. Two, operating, providing the over-road busing transportation. Three, nonprofit employee labor organization representing over-the-road busing and emergency response personnel. C, program elements of per regulation developed under subsection A shall require security training programs to include at a minimum elements to address the following as applicable. One, determining the series of regulations developed under the subsection A shall require security training programs to include at a minimum elements to address the following as applicable. One, determining seriousness of an occurrence of or threat. Two, driver-passenger communication and coordination. Three, appropriate response to defend and protect oneself, use of personnel or other protective equipment. 5, evacuating procedures of passengers over the road busing employees, including individuals with disabilities and elderly. 6, psychology, behavior, and methods of terrorism, including observation and analysis. 7, training related to psychological response or terrorist incidents, including ability to cope with the hijacker behavior, passenger response. 8, in living situation training exercise regarding various threat conditions, including tunnel excavation procedures. 9, recognition and reporting dangerous substances, suspicious packages, and institutions. 10, understanding and security incident procedures, including procedures of the communicating of the emergency response providers and one sense of interaction with the emergency response providers. 11, operational maintenance of security equipment and system. 121, Stat 462, Public Law 11053, August 3rd, 2007, 9/11 implementations. 12, the operating security training activities of the Secretary consider the appropriate. Deadlines. D, required program. 1, the development and submission of Secretary not later than 90 days after the Secretary issues regulation under subsection A. Over the road busing operators shall develop a security training program and in accordance with the regulations, submitting the program to the Secretary for the approval. 2, the approval not later than 60 days after receiving the Secretary training program under the subsection, and the Secretary shall approve the program or required over the road busing operating development to the program to make any revisions program Secretary consider necessary from program to the requirements, regulations, and over-road busing shall respond to the Secretary comments no later than 30 days after receiving them. 3, training not later than 1 year after the Secretary approves the security of training in accordance with subsection. The over-the-road bus operator and developed in program shall complete with the training of over-the-road busing frontier employees where hired an operator more than 30 days preceding such date. For such employees employed less than 30 days over the operator preceding such date, training shall be completed within the first 60 days of the employment. 40 days of regulation program. 4, updates and regulations of the program revisions. The Secretary shall periodically review or update appropriate training regulations issued in subsection A to reflect and changing security threats to each over-the-road busser operator shall revise the training program accordingly to provide additional training as necessary as the employees within the reasonable time for regulations are updated. E, in national training program, the Secretary shall ensure the training program developed under subsection A is a component of national training program established in Section 648 Post-Katrina Emergency Management Reform Act of Public Law 109-295, 6 United States Code 748. Reporting requirements. No later than 2 years after the date of regulation issuances, the Secretary shall review implementation training program of the representative sample of over-road busing operators, over-the-road bus line, front-line employees, report operated appropriate congressional committees of such reviews. The Secretary shall submit the report in both classified reactive formats as necessary. 6 United States Code 1185, Section 1535, over-the-road busing research and development. A, establishment of research and development program, and Secretary acting through the Undersecretary of Science, Technology, and Administration of Transportation Security Administration shall carry out the research development program of the purpose of improving the Secretary over-the-road busing. B, eligible projects. The research for development and program may include projects. 1, reducing vulnerability over-the-road busing stations, terminals, equipment for explosive hazardous chemical, biological, radioactive substances, including development of technology to screen passengers in large numbers with minimal interference and disruption. 2. The test of new emergency response recovery techniques and technologies, including the use of international borders. 3. Develop improved technologies, including those. A. Emergency response training, including training in a tunnel environment if appropriate. B. Secondary redundancy and critical communication, electrical power, computer over-the-road busing control system. 4. The address of vulnerabilities, risk of identifying by the Secretary. C. Coordination with the research initiatives. The Secretary shall enter the research development program consistent with the Transportation Secretary research. Within other transportation security research development programs required by this Act. Shall the extent of the practicable coordinated the research development activities of the Department other than ongoing research and development security-related initiatives, including research and being conducted. A. The Department of Transportation, including the University of Transportation Centers and Institute Centers, grant simulators funded by the Department of Transportation. B. The National Academy of Sciences. C. The Technical Support Work Groups. D. The Federal Department agencies. E. Federal private research laboratories at these institutions, higher education, including historical black colleges, universities, Hispanic serving institution, Indian tribal controlled colleges and universities. 3. Shall carry out the research development project authorized section reimbursement agreement with the appropriate federal agencies if an agency A is currently sponsoring a research development project in similar area. B. Unique facility capability with that would usefully carry out the project. 4. Making award grants entering the cooperative agreement contract transaction reimbursement agreement entities described in paragraph 2. Eligible receipts under section 1532 shall 5 shall make responsible efforts of memorandums understanding the contract grants, cooperative agreements, and other transactions with private operators providing over-the-road busing transportation will contribute asset physical space over the resources. D. Privacy and civil liberty issues. 1. Consultation and carry with the research development project under the section. Secretary should consult Chief Privacy Officer of the Department, Officer of Civil Rights, Civil Liberties of the Department as appropriate in accordance with 222 Homeland Security Act of 2002. Privacy Impact Assessment. In accordance with Section 222 of 705 Homeland Security Act of 2002, the Chief Privacy Officer shall conduct a privacy impact assessment over the officer's civil rights liberties, shall conduct the reviews appropriate for the research development initiatives developed under the section of the Secretary determines could have been impact of civil rights and civil liberties. E. Authorization and appropriations. 1. General, the informal from the amounts appropriated pursuant to 114 W49 U.S. Standard Code amended in Section 1503 of this Act, there shall be available Secretary to carry out these sections. $2 million for the fiscal year of 2008, $2 million for the fiscal year of 2009, $2 million for the fiscal year of 2010, and D. $2 million for the fiscal year of 2011. 2. The period of availability for such sums remains available until expended. Section 1536 1536 Motor Carrier Employee Protection. Section 1536 Motor Carrier Employee Protection. Section 31105 Title 49 United States Code is amended to read as prohibitance of 1. A person not discharge employee discipline discrimination against the employee regarding the pay, terms, privacy, privileges, employment because A. 1 employee of another person employee request has been filed began and proceeding related to the violation of the Commercial Motor Vehicle Safety Security Regulation Standard order or testified or will testify in such proceeding. 2. Person perceives the employee has been filled in the file complainant or has begun about beginning proceeding related violation Commercial Motor Vehicle Safety Security Regulation Standard in order to be employee refuses to operate the vehicle. 1. Operation violation regulation standard order of the United States related to commercial motor vehicle health safety security. 3. The employee responsibly apprehensions of a serious injury to the employee and the public because of the vehicle hazardous safety or security condition. C. The employee accurately reports hours of the duty pursuant to Chapter 315. The employee cooperates. The person who perceives the employee is about to cooperate with the Safety, Security, Investigation, Security, Transportation, Security, Homeland, National Transportation Security Board, National Transportation Safety Board, or E. The employee furnishes the person proceeds as an employee or is about to furnish information to the Secretary of Transportation Security, Homeland Security, National Transportation Safety Board, any other federal, state, and local regularity of law enforcement agency as fact of any incident resulting in injury, death, or individual damage to properly occurring in the connection of commercial motor vehicle transportation. 2. Under the paragraph 1B2, the subsection employee apprehension of a serious injury is responsible for as reasonable individual circumstances confronting the employee would conclude in the hazardous safety security condition established from real danger of the accident, injury, serious impair of health, qualified protection. Employee must have sought out from the employer have been able to obtain correction of the hazardous safety security condition. B. The filing complaints procedures. A. An employee alleging discharge, discipline, discrimination, and violation of subsection A of this section. Any other person of the employee requests for the complaint of the Secretary of Labor no later than 100 days after the alleged violation. All complaints initiated in this section governed by the legal burdens of the proof set forth of 421B on the receiving notification complaint. The Secretary should notify the person of alleged committed violation of filing the complaint. 2. No later than 60 days after receiving a complaint, an investigation notification of the Secretary of Labor shall conduct an investigation to decide whether responsible to believe the complaint has mere or nothing or in writing complaint that the person alleged to have committed the violation of the findings, and the Secretary of Labor is responsible to believe the violation has occurred. As Secretary of Labor shall include the decision, findings, preliminary order, relief provided under paragraph 3 of the subsection B. No later than 30 days after the notice under subparagraph A, the paragraph complaint of the person alleged to have committed the violation and file objections, findings, preliminary order, request hearing of the record of the final objections does not stay in reinstatement or order in preliminary order, or if a hearing is not requested for 30 days, a preliminary order is final, not subjected to the judicial review. A hearing shall be conducted expeditiously, not later than 120 days after the ending of the hearing. The Secretary of Labor shall issue a final order before the final order is issued, preceding the ending of a settlement agreement made by the Secretary of Labor complaint and the person alleged to have committed the violation. 3. The Secretary of Labor decides the basis of complaint of the person's violated subsection A. The section Secretary of Labor shall order in the person 1. Take affirmative action to abate the violation. 2. Reinstate the complaint of the former position of the same pay and term privileges of employment. 3. The pay compensate or damages, including back pay, interest compensation, any of the special damages sustained as a result of discrimination, including litigation costs, expert witness fees, reasonable attorney fees. B. The Secretary of Labor issues as under subparagraph A the paragraph complaint request of the Secretary of Labor may assess against the person when the order is issued the costs, including attorney fees, reasonably incurred by complaint bringing in the complaint. The Secretary of Labor shall determine the cost of reasonable wear incurred. C. The relief of an action under subsection B may include punitive damages amount not to exceed $2,500,000. Deadline de novo review. The respect of a complaint under paragraph 1 and the Secretary of Labor has not issued a final decision of 210 days of filing a complaint. If the delay is not due to the bad faith of an employee, the employee may bring an original action of law, equity, not of de novo review of appropriate district of the United States, which shall have jurisdiction over any action with regard to the amount of controversy which the action shall at request of either party to such action be tried by the court of a jury. Deadline. A judicial review of any of the personal advisory affected by an order issued a hearing under subsection B of this section may file the intention review no later than 60 days after the order is issued to the Court of Appeals of the United States of the circuit in violation occurred or the person has died in the date of the violation. Review shall conform to the Chapter 7 or the Title 5. The review shall be heard decided expeditiously, and according to Secretary of Labor shall object to the review under the subsection is not subject to the judicial review or criminal proceedings, civil actions and enforcement. If the person fails to comply with the order issued in subsection B, the Secretary of Labor shall bring in civil action and enforce the order. The District Court of the United States of the judicial district in which the violation occurred. No preemption. Nothing section preempts, diminishes any other safeguards against discrimination, demotion, discharge, suspension, threats, harassment, reprimanded, retaliation, or any other manner of discrimination provided by the federal, state law. G. Rights are retained by the employee. Nothing in this section shall be diminished by the rights and privileges, remedies of any employment under the federal, state law, or under any collective bargaining agreement. The rights and remedies in this section may not be waived by any agreement, policy, form, or condition of employment. H. The disclosure of identity. 1. Expects to provide paragraph 2 the subsection of the written consent of the employee, Secretary of Transportation, Secretary of Homeland Security, and may not disclose the name of the employee who has provided information of alleged violation of this part. The regulation described or issued is under the provisions to the Secretary of Transportation, Secretary of Homeland Security shall disclose the Attorney General the name of the employee described in paragraph 1. The subsection is if the matter referred to as the subsection, paragraph 1 of the subsection, the matter is referred to as the Attorney General for the enforcement. The Secretary making the such disclosure, she shall must provide reasonable advance notice and infected employee disclosure of the person identity. Identifying information is to occur. I. Process of reporting security problems to Homeland Security. 1. Establish the process. 1. Regulation notice. The Secretary of Homeland Security shall establish the regulations after the operation of the notice commitment of the process which any person may report to Secretary of Homeland Security regarding motor carrier vehicle security problems, deficiencies, and vulnerabilities. 2. Acknowledgement of a receipt. If the report is under paragraph 1 identifies the person making the report, Secretary of Homeland shall respond promptly to such person acknowledging receipt and report. 3. The steps of addressing a problem, the Secretary of Homeland Security shall review, consider the information provided, the report, and submitted under paragraph 1, and shall take appropriate steps to address any problems and deficiencies identified. J. Definition. In the section, employee means a driver, commercial motor vehicle, including independent contractor when personally operating commercial motor vehicle, a mechanic, freight handler, and individual, not an employee or not an employer who 1. Directly commercial motor vehicle safety security course employs a commercial motor vehicle. 2. And is an employment of the state government and a political subdivision state acting in the course of employment. Section 1537, a Unified Carrier Registration System Agreement. A. Reenactment of the SSRS. Section 14504 of Title 49 United States Code as this section of December 31st, 2006 shall be effective of the law of the United States of the period beginning in January 1st, 2007 and ending in January 1st, 2008, effective the final regulations issued in the pursuant to subsection. Effective date, termination date is 49 United States Code 14504. No. B. The deadline final regulations no later than the October 49 United States Code 13908. No. Is no later than October 1st, 2007. The Federal Motor Carrier Safety Administration shall issue a final regulations to establish Unified Carrier Registration as required by 13908 in Title 49 United States Code. Set the fees Unified Carrier Registration Agreements calendar 207 and subsequent calendar discharge for the motor carriers, motor private carriers, freight forwards under such agreements as required in 14504A of Title 49 United States Code. Repeal of the SSRS. Section 4305, the Safe, Accountable, Flexible, Efficient Transportation Equity Act. A legacy of users of 1119 Stat 1764 is amended by striking the 1st January and all that follows in the acts inserting January 1st, 2008 and 49 United States Code 14504. Note. Section 1538, School Bus Transportation Security. School bus security risk assessment no later than 1 year after the date of enactment of the Secretary shall transmit appropriate congressional committees of a report, including classified report, appropriated containing comprehensive assessment of the risk of terrorist act on the national school bus transportation in accordance with the requirement of the section. B. The consistent Risk assessment shall be included. Reports, deadline, classified information. 121 Stat 468, Public Law 11053, August 3, 2007. 1. An assessment of the security risks of national school bus transportation include publicly and privately operated systems. 2. An assessment action already taken by the operators other than identifying security risks. 3. Assessment whether additional actions investment necessary to improve the secondary passenger traveling on school bus. List of such actions and investments and appropriate. C. The consolation conducting a risk assessment of secondary shall consult an administrative and official school system representatives of school bus industry, including both publicly, privately operated, public safety and law enforcement officials, non-profit employee labor organization representing school bus drivers. Section 1539, Technical Amendment, Section 1992, D7 of Title 18 United States Code is amended, inserting intercity bus transportation after includes. Section 1540, Truck Security Assessment. Definition: for all purposes of the section, the term truck means self-propelled towed motor vehicle used on a highway, interstate, commercial, or transportation property with a vehicle. 1. High growth has a gross weight vehicle weight rating of gross combination weight in gross vehicle weight and combination weighting of 4,536 kilograms or 10,000 pounds or more, whichever is the greater. 2. United States transportation material is a Secretary of Transportation hazardous under Section 5103, Title 49 United States Code. Transported quantity regard of placarding regulations prescribed in Secretary under Subtitle B, Chapter 1, Subchapter C, in the Title 49 United Code Federal Regulations. Deadline reports. In general, no later than 1 year after the date of enactment of this Act, the Secretary Coordination of the Secretary of Transportation shall transmit a report of appropriate congressional committees of this truck security issues, and including 1. In security assessment of the trucking industry. 2. The assessment of the actions already taken in both public and private entities to address the identified security risk. 3. The assessment of economic impact, security upgrades, trucks, truck equipment, truck facilities, and have been truck industries and employees, including independent owner-operators. 4. Assessment of ongoing research, public-private entities, and needed additional research of this security. 5. The assessment of the industry best practices, enhancement security. 6. Enhancement of current status of security trucking parking. 5. C. Format: the Secretary may submit a report of classified redactment formats. The security determines if such action is appropriate or necessary. Section 1541, Memorandum of Understanding Annex. Deadline 6, United States Code 1186. No later than 1 year after the date of enactment, the Secretary of Transportation shall execute and develop and annex a memorandum of understanding between two departments signed on September 28, 2004. Governing the specific rules, delineations, responsibilities, resource committees, Department of Transportation, Department of Homeland Security, actively addressing motor area transportation security matters, including over-the-road busing security, shall cover the process departments follow to promote commission's efficiently non-duplication of effort. Section 1542, DHS Inspector General Report Trucking Security Grant Program. A initially report no later than 90 days after the date of enactment. The Inspector General of the Department of Homeland Security shall submit a report appropriate for the congressional committees of the Federal Trucking Industry Security Grant Program for fiscal year of 2004 through 2005, addressing the grant announcement, application receipt, review, award, the monitoring, closing process. The states amount obligated to expending under the program of the fiscal years of 2004 and 2005 are for A. Infrastructure protection, B. Training, C. Equipment, D. Educational materials, E. Program administration, 5. Marketing, G. Other functions, B. The subsequent report no later than 1 year after the date of enactment. The Inspector General date of the Homeland Security shall submit a report of appropriate congressional committees. 1. Analysis performance effectively of the Federal Transportation Industry Secretary Grant Program, the need for the program, using all years of available data. 2. Make recommendations regarding the future of the program, including the operations and improving effective utility program, motor carrier security. Subtitle D, hazardous material and public and security.